Thank you very much for joining us today. Now, the Member of Parliament for Old Tafo and Echo Vincent Asafwa has sued the Attorney General over publication of petitions to remove the Chief Justice Torkornoo from office. Mr. Asafwa is praying the Supreme Court to declare as unconstitutional ongoing processes to have the Chief Justice removed from office. He says the President erred procedurally. This comes days after President Mahama forwarded 3 separate petitions to the Council of State, kickstarting the constitutional process for the removal of the Chief Justice or the Justice of the Highest Court. But according to the MP, the President's failure to notify the Chief Justice about the petitions violates the 1992 Constitution. Hence, the ongoing process must be declared null and void. We're bringing you details of what Mr. Asafwa is seeking, but let's quickly get a thought of private legal practitioner Martin Kpebu. Good afternoon to you, sir. Thank you so much for joining us. Hello, Mr. Kpebu, can you hear us?
Yes.
Thank you very much for joining us. Good afternoon to you.
Yes.
I'm sure you know the processes, and of course, this is not the first time there has been a petition to remove the same Chief Justice. Even under the previous administration, we saw that. But would you say, based on what you know, that there's indeed a breach in procedure? The reason the plaintiff, is asking that the court declares the steps taken by the president as unconstitutional?
No, there is no breach at all. There is no breach in the procedure. Listen. The Supreme Court held, right now, if you read the Constitution, you'll not find what I'm about to say. Rather, it is in the case of Frank Ejechu versus Attorney General. So now, what it is that in Ejechu versus Attorney General, it was held that when it comes to the removal of the Chief Justice, when the President receives the petition, he should consult the Council of State to make. And the President is the one who ultimately rules, like a judge. He will make a determination whether there is a prima facie case. So now, for the President to make a determination whether there is a prima facie case, he needs to consult the Council of State, which he has sent. It's only part of the step. Now, it's also the case that when the President is about to make the prima facie case, sometimes you ask the Chief Justice to comment. That is, and let's watch the words. It's only when the petition is well drafted and well grounded. So in other words, what I'm saying is that if the petition has so many problems that, let's use the strongest Ghanaian language so that it would sink in. If the petition looks hopelessly bad, the President doesn't need to invite the Chief Justice to answer before he will make that determination. So let me show you examples. Today, assuming a petition is sent, then the petition is not signed, then there is no name of the petitioner. So how would you ask the Chief Justice to answer when the Chief Justice doesn't even know the accuser? So because of petty mistakes and serious mistakes with petitions, it's reasonable for the President to open it, look at it, and then ask for the advice of the Council of State sometimes before asking the Chief Justice to answer. So that in situations where the petition is hopelessly bad, they would not ask the Chief Justice to respond. So for me, it's okay, it's a lawsuit, but in a way it helps to develop our jurisprudence. But the key thing we should watch is that the President will not send a petition that is hopelessly bad to the Chief Justice. And so to determine whether something is hopelessly bad, it's reasonable for the President to ask for the advice of the Council of State without first going to the Chief Justice. So the President can say, in forwarding it to them, that, look, I noticed there's XYZ lacking in the petition. It makes it deficient. I don't think I want to forward it to the Chief Justice. What do you think? Etc. So instead of when they look at it and say, oh, no, we disagree. We think it is something that should go. And then upon second thought, then upon reviewing the response of the Council of State, if the President agrees with them, then he will send it. So I don't think that he has breached the law. So where he will be breaching the law is assuming he had looked at it with the Council of State and then made the determination that there is a prima facie case when he has not sought the comments or the defense of the Chief Justice. That's the one that you say he has breached the law, because that one then it means that Mr. President has taken a decision against the Chief Justice without first hearing the Chief Justice. That's where it arises.
So if I get
in our past, it's important we mention this. There was once a petition that went without signature. Instead of Kpebu to throw it out, and at the time the Kpebu now called the petitioners to come and sign. So another president looking at it may say, no, I won't call the petitioners. I want to throw it out. It's faceless. So let's give the president the opportunity to decide.
If I get your explanation correctly, you are disagreeing with the relief sought by Mr. Safwa that upon a true and proper interpretation of Articles 146 and 296 of the Constitution, the President was necessarily supposed to notify the CJ about this.
No, sorry, I lost you a little bit.
I'm saying that based on what you've just said, you obviously disagree with that relief sought by Mr. Safwa in court, which says that upon proper interpretation of Articles 146 and 296 of the Constitution, the President erred by failing to notify the CJ before taking this matter to the Council of State.
Absolutely. I disagree with him. And even when you read the frank-ejecting case, the Attorney General, they made those, they gave such indications that, look, sometimes the petition can be frivolous, terribly bad. Look, let's give another example. And sometimes let's not think that these are far-fetched. You know, in a democracy, somebody may not, okay, let's not give reasons why, but you know, somebody can just write a petition against Chief Justice, and it will just be full of insults. The Chief Justice is X. The Chief Justice is why. I mean, all unprintable words, giddy, and doesn't say much, but just full of insults, invectives, vitriol. You think it cannot happen in a democracy? Yes, for all manner of reasons, a petition can be like that. And you are saying a petition that's just full of insults, petition for removal of Chief Justice, doesn't give any tangible reason, just begin to insult, just begin to say unsavory things like this. Then we are saying that pass it on to the Chief Justice to comment before the President will say, oh no, so I don't see any reason stated there.
My last question to you is, again, based on what you're saying, you think that the President finds substance in the petitions and is the reason he straight ahead went to the Council of State?
No, that's not what I'm saying. That the President has to peruse it and see if it meets some basic requirements of the law before he will invite the comments of the Chief Justice. And in perusing it, he's allowed to seek the advice of the Council of State. So that's what I see that they are doing. You look at it, listen, should we invite Chief Justice? Or looking at it, it's so bad that it should be thrown away. So there's that level. If it's terribly bad, and no lawyer will tell you that no, he disagrees. If it's terribly bad, it can be thrown out without asking the Chief Justice to respond. So to determine whether it's terribly bad, if let's say the President has made his mind that it is terribly bad, he can ask the Council of State, I think this is terribly bad. I want to throw it out without asking the CJ. What do you think? Then they will give their response. Okay, Beatrice.
We'll have to end it here. Yes, thank you very much, Martin Kpebu, private legal practitioner.